To Module 2 Sentencing Structures. Today we will be talking about sentencing structures as it relates to both state and federal systems. And of course, we know that they can vary widely depending on the type of crime that's committed, with the offender's criminal history and also contingent on the jurisdiction. So here's a breakdown of some of the types of sentencing, including mandatory minimum sentences, three strikes, and others that we'll be talking about. So we'll go to the next slide here. So in this, we'll be discussing state and federal systems, criminal history, the jurisdiction, mandatory minimums, three strikes, some sentencing guidelines. We'll be discussing probation as a sentencing structure, truth in sentencing, sentencing enhancements, as well as capital punishment. So let's go ahead and dig into the mandatory minimum sentences. We know mandatory minimum sentences are laws that require judges to impose minimum sentence for certain crimes, regardless of any mitigating factors such as the offender's background or the circumstances of the offense. So, in the federal system, we know that the federal system has a number of crimes that carry mandatory minimums sentences, especially for drug offenses. So, for example, if someone is in possession of certain amounts of drugs, there will be more than likely a mandatory minimum sentence attached to it. So, like 5 years for trafficking 5 kilograms of cocaine. In the state system, we know that many states have their own mandatory minimum sentencing laws, especially for serious crimes like drug offenses, firearm offenses, or even sexual assault. So, for instance, in some states, if a conviction is for drug trafficking, again, just like the federal system, for a certain amount of drugs, they may result in something like a 3 year sentence. But it can, of course, go the more drugs you're in possession of drugs, the higher the sentence. Okay. Next slide there. Three strike laws. We know with regards to three strike laws, the strike laws basically mandate life sentences for individuals that are convicted of three or more serious offenses. Typically, have to do with violent offenses, violent felonies, regardless of the severity of the third offense. So basically, if someone commits a crime, it's a heinous, violent act, first time, second violent act, and let's say, for example, if the person gets picked up on a felony theft charge, well, that does meet the criteria for the three strikes, and that person could be sentenced to life in prison. So in the federal system, there is a version of the three strikes for repeat offenders under the three strikes law. And again, in the state jurisdiction, many states like California have adopted the three strike laws, and I know in particularly, they have that where you can create where you may be convicted of two serious felonies, and then that third offense may be somewhat small. Yeah, but you're going to do life in prison under that particular statute with regards to California. Moving on to the next sentencing structure here, we're looking at sentencing guidelines. And interestingly enough, with sentencing guidelines, they do provide a framework to guide judges in determining what appropriate sentences are for a given offense. So they're oftentimes based on the offense's severity and, of course, the offender's criminal history. So in the federal jurisdiction, the federal sentencing guidelines are used to really determine and they recommend a sentence range for a particular defendant, taking into account some factors like the offense severity, the defendant's criminal history, and specific case circumstances. Now, judges have the discretion to vary from these guidelines, but they must provide reasons for any particular deviation. Now, in the state jurisdiction, many states have their own sentencing guidelines, but not all states use them. Some states, like Michigan, of course, Minnesota and Pennsylvania, they have their sentencing guidelines that help standardize certain sentences. So these can sometimes be mandatory or present an advisory capacity to the state. So, and let's go ahead and move on. Let's look at probation. Of course, we know with probation is a sentence option that really allows offenders the opportunity to remain in the community, but under a sentence of supervision instead of serving time in prison. Again, in the federal jurisdiction, federal system, probation is often used for nonviolent offenders or those with no previous criminal history. However, there are certain federal offenses, like drug trafficking, for example, where probation is prohibited or more than likely limited or restricted. On the state side, we know that probation is commonly used in state systems for less severe offenses, especially for those first time offenders or those convicted of misdemeanors. Some state laws may also allow for a split sentence, in other words, where the offender does serve some time under a sentence of incarceration, but then they come out and they're placed on probation for another particular offense that may have been committed. So, with regards, we're looking at truth in sentencing. Truth in sentencing laws really require the offender to serve a substantial portion of their sentence before becoming eligible for parole. Often, you see a lot of truth in sentencing guidelines around meeting a mandatory of 85% of their sentence there. With regards to the federal system, we know that the truth in sentencing laws mandate that prisoners serve at least 85% of their sentence for some serious crimes such as violent offenses before they're eligible for an opportunity for parole. In the state side, many states have also adopted truth in sentencing guidelines that require offenders really to serve a minimum percentage of their sentence. And that can either range from somewhere between 50% to 85% for those nonviolent offenders. For a nonviolent offender, they may lower the threshold to somewhere around 50%. But for those violent offenders, more than likely they're going to require them to do it 85% of their sentence. Moving right along, we're looking at sentencing enhancements. So, sentencing enhancements really increase the severity of a sentence based on specific aggravating factors, such as was there a weapon that was used, any prior convictions, their history of that particular offender, or the impact that they may have held on a victim. So on the federal side, we see in the federal system that enhancements can be applied based on factors like using a firearm, the weapon that we talked about, in a crime, or having prior convictions for similar offenses. So, for example, federal law does provide enhanced sentences for individuals that may be convicted of crime involving firearms or maybe selling drugs near schools. On the state side, it's similar. States also apply sentencing enhancements, particularly for repeat offenders or if certain aggravating factors are present. Again, so some states like New York have enhanced penalties for crimes that may be motivated by hate. That's another component of sentencing enhancements there on the state side. Now we come to capital punishment. And of course, the death penalty is, as we know, is the most severe form of punishment. It's carried out in cases particularly for egregious crimes such as murder. And on the federal side, we know that the federal system reinstated the death penalty in 2020. Now, this was done under the Trump administration. And of course, we hear a lot of conversation right now in the Biden administration how Biden had commuted some sentences with regards to those individuals that were on federal death row. But there are some restrictions with regards to to executions. Now, the death penalty does apply only to certain federal crimes, and most of the time this involves terrorism and particularly brutal murders. And those brutal murders are like first-degree murder, which is a murder that is committed, premeditated, deliberate. Oftentimes, it attaches to something like robbery, things of that particular nature. On the state side, we see some states like Texas. Now, they actively use the death penalty, as well as states like Alabama, while other states like California, Oregon, and Pennsylvania, even in Illinois, have abolished or placed moratoriums on the death penalty. Yeah. And then lastly, one of the things I want to touch on in the conclusion of this particular presentation is that mandatory minimum sentences and three strike laws are used to create certainty and uniformity in sentences, but they can limit a judge's discretion and sometimes lead to overly harsh sentences. I think a lot of these mandatory minimum sentences are also have been blamed for some of the what we see overcrowding in prisons. And so we know that with regards to sentencing guidelines, they do provide a framework to ensure that consistent sentencing is somewhat flexible in consideration of some specific case facts. As with regards to probation and truth in sentencing laws, other alternatives to incarcerations are to ensure that offenders serve substantial portion of their sentences. Now we know with regards to sentencing enhancements, these can sometimes escalate punishment based on aggravating factors that we discussed, such as was there a weapon used, things of that particular nature. But with regards to capital punishment, this right here remains the ultimate punishment. And of course, we know that that punishment is used for terrorism and some of the most egregious, brutal murders, things of that particular case. So each of these sentences, as we know, reflects a balance between deterrence and punishment, things that we discussed in Module 1, but they differ with regards to certain jurisdictions in state and federal government. Again, I hope, there's my hope that I hope that you got something out of this particular presentation. And again, I look forward to doing more of these particular presentations, and I hope that this was very helpful. Thanks again. We'll talk again. Bye now.